Welcome to this deep dive. You've sent us some fascinating material, and today we're going to unpack the governance structures and land and resource management rights of Indigenous peoples across several key regions.
Yeah, we're looking at Australia, the USA, Canada, New Zealand, even Scandinavia and Greenland.
Exactly. And our mission here is really to cut through the considerable complexity and pull out the core insights. We want to understand Indigenous self-determination better and how these groups interact with non-Indigenous governments.
We're aiming for those aha moments.
Yeah.
The key takeaways that give you, the listener, a solid grasp of this important global picture without getting totally bogged down in detail.
Right. And the main source we're diving into is a piece by Garth Netheim, Indigenous People and Government Structures, a comparative analysis of land and resource management rights.
That's the one. It's from 1995, published by Aboriginal Studies Press. It came out of a pretty extensive research project, discussion papers, workshops, lots of expert feedback. So it's a really solid foundation for what we're discussing.
And what I found particularly interesting is that it doesn't just focus on lands currently under native title.
No, it makes a point of looking at areas where native title might have been legally extinguished, certainly under Australian law, but where Indigenous peoples still have ongoing rights and interests.
So it's a broader look at how these connections and rights persist, even when the formal legal status changes. A really crucial point.
Absolutely. And the original research was aimed at providing guidance for some pretty high-level bodies in Australia, the National Native Title Tribunal, the federal court, Indigenous groups in negotiations, even parliamentarians.
So for you listening, wanting to get up to speed quickly but thoroughly, this comparative approach was kind of designed to highlight the really critical issues across these different places.
Precisely.
Okay, so where should we start? Maybe with the big picture stuff. What about the international law standards that kind of shape how we think about Indigenous governance?
Good place to start. A really fundamental principle is non-discrimination. But it's more nuanced than just treating everyone identically on the surface.
Right.
The International Convention on the Elimination of All Forms of Racial Discrimination, ICER actually recognizes that sometimes you need special measures.
Special measures.
Yeah, things designed specifically to help groups overcome historical disadvantage. And importantly, ICER says these aren't discriminatory if the goal is genuine equality, achieving a level playing field.
Okay, so it's about substantive equality and not just formal sameness.
Exactly. And ICER also guarantees the right to own property and inherit without racial discrimination. Now, here's a key insight. This wasn't just theoretical in Australia. The High Court actually relied on Australia's ratification of ICER to strike down laws in Queensland and Western Australia that were attempting to extinguish native title.
Wow, really? Which cases were those?
That was in the Mabo decision regarding Queensland, and then later in the Western Australia v. Commonwealth case. So it shows how international agreements can have real teeth domestically.
That is an aha moment. International law having direct, concrete legal impact within a country. Now, does it go beyond just property ownership? What about using the land and resources?
Yes, definitely. Article 27 of the International Covenant on Civil and Political Rights, the ICCPR, is really key here. The UN Human Rights Committee, which interprets the ICCPR, has consistently said this article protects the rights of Indigenous peoples to enjoy their culture, and often that culture is deeply tied to their traditional lands and resources.
So it connects culture directly to land use.
Precisely. They've emphasized that culture isn't static. It manifests in ways of life linked to the land. And importantly, this means states often need positive legal measures to protect these rights, and Indigenous peoples need to be able to participate meaningfully in decisions affecting their lands.
Having a real say, not just being informed after the fact.
Exactly. It's about participation and protection. And even though the UN Declaration on the Rights of Indigenous Peoples wasn't finalized back in '95 when this research was done, the draft principles were already incredibly influential.
And what were some of those key draft principles?
Well, Article 25 talked about the right to maintain and strengthen that distinctive spiritual relationship with traditionally owned or used lands, waters, seas, resources. It's about connection.
A deep spiritual connection.
Yes. Then Article 26 asserted the right to actually own, develop, control, and use those lands and resources. It called on states to give legal recognition and protection, respecting Indigenous customs and land tenure systems.
So moving towards real control and recognition of traditional systems.
Right. And Article 28 focused on the environment, the right to conservation, restoration, protection of the total environment, and its productive capacity, a kind of stewardship right.
And what about development projects? That's often a flashpoint.
Absolutely. Article 30 was crucial there. It stated the right for indigenous peoples to determine their own priorities and strategies for using their lands and resources. And critically, it included the right to free, prior, and informed consent, FPIC, before projects affecting them could be approved.
FPIC, that's a term we hear a lot now. So the Cs were already there in the draft declaration.
Very much so. These international principles, taken together, really paint a picture emphasizing self-determination, control, consent, and recognizing those deep cultural and spiritual connections to land.
Okay, that gives us a strong international framework. Let's see how this plays out on the ground. How about we jump over to the United States? How do indigenous peoples there manage their environment and resources?
Okay, the U.S. context. Tribal powers to manage the environment on reservations and control resources. It largely stems from this common law recognition of their pre-settlement occupation. The courts basically acknowledged they were organized societies with inherent rights even before Europeans arrived.
But the history of U.S. Indian law is, well, pretty tumultuous, isn't it? Lots of policy swings.
Oh, absolutely. A real roller coaster. You can sketch out rough phases. Discovery, conquest, treaty making, then removal, relocation, setting up reservations, then the allotment and assimilation policies, trying to break up communal lands.
A really destructive period, that one.
Hugely. Then you had the reorganization and self-government phase, a move back towards more autonomy, followed, unfortunately, by the termination era, another damaging attempt at assimilation, stripping tribes of recognition and land, and finally, the current era of self-determination, which, at least in principle, emphasizes tribal sovereignty.
Understanding that history seems essential to grasping the current legal situation. You mentored inherent tribal sovereignty. What does that mean practically?
Think of it as the governing powers tribes didn't give up, powers they held before colonization, and that weren't explicitly extinguished by treaty or federal law. So typically this means governing their own members and territory.
But it's usually limited when it comes to non-members on the reservation, right?
Generally, yes. Tribal criminal jurisdiction over non-Indians was largely removed by the Supreme Court. Civil jurisdiction is also limited, primarily governed by what's called the Montana test, stemming from the Montana v. United States case.
The Montana test, okay, what does that allow?
It sets out two main exceptions, where tribes can regulate non-members on reservation lands, even on land owned in fee simple by non-Indians. First, if non-members enter into consensual relationships with the tribe or its members, think leases, contracts, business dealings.
So if they voluntarily engage with the tribe.
Right. The tribe can regulate that specific engagement. The second exception is if the conduct of non-Indians, even on their own land within the reservation, threatens or directly affects the tribe's political integrity, economic security, or health and welfare.
That sounds like it could cover quite a bit, but probably leads to disputes.
It's definitely a source of ongoing litigation. It's a high bar to meet, proving that direct threat. So tribal civil authority over non-members is quite constrained.
Okay. Now, what about the federal government's role, that famous trust responsibility? What's the core idea there?
The trust responsibility is foundational. It goes back to Chief Justice Marshall describing tribes as domestic dependent nations and their relationship with the U.S. government as being like that of a ward to his guardian.
So a protective duty?
Essentially, yes. It imposes a legal and moral obligation, a fiduciary duty on the federal government to act in the best interests of tribes, especially regarding their lands, resources, and assets. The government is supposed to protect tribal interests.
But has that always worked out in practice? Has it stopped Congress from, say, taking tribal land?
Well, that's the tension. The trust responsibility exists, but Congress also asserts what it calls plenary power over Indian affairs, basically, near absolute authority. For a long time, courts tended to just assume Congress acted in good faith, even when its actions harmed tribes, like in the Lone Wolf case.
So the trust responsibility didn't really limit Congress.
Not effectively for much of history. But there was a significant shift, or at least a clarification, with the United States v. Sioux Nation of Indians case in 1980. The court reaffirmed Congress's power to take land, but said the government couldn't just presume good faith anymore.
Ah, so they had to actually look at whether fair compensation was paid.
Exactly. It required a thorough examination of the government's actions and whether it met its fiduciary duty to provide fair compensation. It didn't stop the taking, but it strengthened the requirement for just compensation based on the trust relationship.
Okay, that's a crucial nuance. What about specific resources? Water is always contentious. How are Indigenous water rights handled?
Very contentious. Indian reserved water rights are a huge deal. They come from the Winters v. United States case back in 1908. The Supreme Court basically said when the U.S. government set aside land for a reservation, it implicitly reserved enough water to fulfill the reservation's purposes.
Even if the treaty didn't explicitly mention water.
Correct. And crucially, these Winters rights usually have a priority date tied to when the reservation was established, making them often much older and therefore legally senior to water rights granted later under state law.
I can see how that would lead to conflict with states and other users.
Big time. The federal government, under its trust responsibility, is supposed to help tribes quantify and protect these rights. But states often push back. The McCarran Amendments allowed states to force tribes into state-run water adjudications to sort out all the rights in a river system, which tribes often see as hostile forums.
And hunting and fishing rights, also very important culturally and for subsistence.
Hugely important. Many treaties explicitly reserve the right for tribes to continue hunting and fishing in their traditional areas, often off-reservation. The courts, like in United States v. Winans, recognized these weren't rights granted by the government, but rights reserved by the tribes.
Rights they already had.
Exactly. They're fundamental to survival and culture. But again, conflict arises with state conservation laws. The Puyallup II case established that states can regulate off-reservation treaty fishing for conservation purposes, but only if it's necessary and doesn't discriminate against treaty fishers.
So a balancing act.
A constant balancing act. And then you get into really complex issues like in the Washington Phase 2 litigation, do tribes have a treaty right to have fish habitats protected from degradation by things like logging or dams? The courts have grappled with that, with mixed results. It's still a live issue.
Okay. And mineral resources on reservations.
Generally, tribes own the mineral resources beneath their lands.
Yeah.
Federal laws like the Indian Mineral Leasing Act of 1938 and later the Indian Mineral Development Act, or IMDA, were set up to allow tribes to lease these resources, ideally for economic benefit.
With federal oversight.
Yes, the government has a trust duty in managing these leases. Although, interestingly, under IMDA, Congress actually limited the government's financial liability for mismanagement to some extent. More recent laws like FOGRMA, the Federal Oil and Gas Royalty Management Act, and the Indian Energy Resources Act aim to improve royalty collection and give tribes more control and support in energy development.
And finally, quickly, what about zoning? Can tribes control land use on their reservations through zoning?
It's complicated. Tribal zoning power is strongest over land held in trust for the tribe. But reservations often have a mix of trust land and fee land, land owned outright, sometimes by non-Indians.
Ah, the checkerboard pattern.
Exactly. Supreme Court decisions like Oliphant, which limited criminal jurisdiction, and Montana, which limited civil jurisdiction over non-members on fee land, significantly impact tribal zoning authority over those fee lands. So, the exact boundaries of tribal zoning power, especially over non-member lives, remain somewhat fuzzy and often contested.
So for the U.S., it's a picture of inherent sovereignty, recognized rights like water and treaty rights, but constantly mediated and often limited by federal plenary power, the trust relationships complexities, and court decisions defining jurisdiction, especially over non-members.
That sums it up pretty well. A very complex legal landscape shaped by centuries of shifting policies and legal battles.
Okay, let's shift gears and look north. How does Indigenous resource management and governance look in Canada?
Canada also has a foundation in treaties, though the process and outcomes varied across the country. Many historical treaties involve First Nations ceding large territories in exchange for smaller reserves, some payments, guarantees of hunting and fishing rights, and promises of non-interference in their way of life and governance.
Promises often broken, I imagine.
Sadly, yes. That was often the pattern. And then came the Indian Act, starting in 1876 and amended many times.
We touched on this earlier. It had a huge, often detrimental impact, right?
Immense. It wasn't about partnership. It was largely about control and assimilation. It dictated who qualified as an Indian. It disenfranchised women who married non-status men. It imposed the band council system, often beholden to the federal government. It facilitated taking children to residential schools, banned ceremonies like the potlatch, restricted movement off reserves with the pass system, limited access to courts. It permeated almost every aspect of life.
It sounds incredibly oppressive, a tool for undermining Indigenous societies.
That was largely its effect, yes. And for a long time, after a late 19th century court case called St. Catherine's Milling, the legal view seemed to be that Aboriginal title was quite limited, sort of overshadowed by Crown title. Indigenous rights were largely ignored or suppressed.
So when did things start to change? When did recognition start to gain traction?
The real turning point was the Calder case in 1973, brought by the Nisga'a Nation in British Columbia. The Supreme Court was actually split, but significantly, several judges acknowledged that Aboriginal title existed as a legal right based on prior occupation, independent of the Crown.
Even though the Nisga'a didn't technically win the case.
Right. But it was a wake-up call for the federal government. It showed that Aboriginal title was a real legal issue they couldn't just ignore anymore. Shortly after, the government introduced its first comprehensive land claims policy, opening the door to negotiate settlements.
And the courts continued to play a big role after Calder.
Absolutely. The Canadian courts have been central in defining and affirming Aboriginal rights and title. The Vander Peak case in '96 was key for defining Aboriginal rights, things like fishing or hunting rights. The court said these rights protect practices, customs, and traditions that were integral to the distinctive culture of the specific Aboriginal group before contact with Europeans.
So connecting rights to pre-contact culture?
Yes, and establishing specific ways courts should interpret treaties and evidence related to these rights, generally favoring the Aboriginal perspective. These are called the canons of construction.
And then came Delgamuukw. That sounds familiar.
Delgamuukw in 1997 was massive for Aboriginal title. It confirmed that Aboriginal title is more than just the right to do specific activities like hunting. It's a right to the land itself. It arises from pre-sovereignty occupation and the relationship between Indigenous legal systems and the common law.
A right to the land. That's a huge distinction.
It is. And Delgamuukw was also incredibly important for recognizing the validity of oral history as evidence in court.
Ah, yes, that was a major hurdle, wasn't it? Proving historical occupation using traditional knowledge.
Exactly. The trial judge in Delgamuukw had largely dismissed the oral histories presented by the Gitxsan and Wet'suwet'en chiefs, but the Supreme Court strongly criticized that, saying courts have to adapt evidentiary rules to account for the nature of Aboriginal societies and how history and land tenure are recorded and passed down. It was a vital step.
So with Calder opening the door in cases like Vander Peet and Delgamuukw defining rights and title, what did the negotiated settlements start to look like?
They evolved. The early comprehensive land claims agreements, post-Calder, often involved extinguishing Aboriginal title in exchange for defined land parcels, financial compensation, and often what were called co-management regimes for resources.
Co-management meaning shared decision-making.
Shared, but often with government having the final say. However, over time, especially into the '80s and '90s, the agreements became more sophisticated. They started including stronger Indigenous participation, sometimes actual decision-making power on resource boards, revenue sharing from resource extraction, and crucially, elements of self-government.
Can you give some examples?
Sure. The Gwich'in Agreement in the Northwest Territories and the Nunavut Land Claims Agreement are good examples of this shift. They provided for significant land ownership, including subsurface rights in some areas, financial packages, and guaranteed roles in land and wildlife management.
And Nunavut itself is the ultimate example, right? Creating a whole new territory.
Absolutely. The Nunavut Agreement led to the creation of the Nunavut Territory in 1999. It's a public government, but Inuit make up the vast majority of the population and dominate the legislative assembly. They got title to a huge amount of land, mineral rights on part of it, funding, and guaranteed representation on major management boards like the Nunavut Wildlife Management Board. It's a profound example of self-determination achieved through negotiation.
Beyond these big land claims, have Canadian courts recognized other types of rights?
Yes. The Vander Peet trilogy of cases also affirmed commercial Aboriginal rights, the right to harvest resources for sale, not just subsistence. In other cases, like Adams and Coate, confirmed that Aboriginal rights, like fishing rights, can exist independently of Aboriginal title, meaning they can apply in areas where title itself might not be proven or claimed.
And what about the government's responsibility when its actions might impact these rights?
This is another huge development in Canadian law. The duty to consult and, where appropriate, accommodate. The Supreme Court has established that the Crown has a legal duty to consult with Indigenous groups whose Aboriginal or treaty rights might be adversely affected by government action or decisions like issuing permits for logging or mining.
A duty to talk before acting.
Yes, and the level of consultation required depends on the strength of the potential claim and the seriousness of the potential impact. It can range from just providing information to deep discussion to potentially needing the full consent of the Indigenous group if the impact is severe or unproven rights or title lands. This duty is a major factor in resource development across Canada now.
So Canada seems to have moved from outright suppression under the Indian Act towards a framework that legally recognizes Aboriginal title and rights, relies heavily on negotiation for comprehensive settlements, often including self-government, and imposes a significant duty on the government to consult before impacting those rights.
That's a good summary of the trajectory, yes. It's still evolving, and there are many ongoing challenges and debates. But the legal and policy landscape has shifted dramatically since the 1970s towards greater recognition and negotiation.
Okay, that's a fascinating contrast with the U.S. trajectory. Now let's consider somewhere perhaps less familiar to many listeners in this context, Native Alaska. It has a pretty unique history, doesn't it?
It really does. Alaska's history is distinct, partly because of the harsh climate and the fact that significant non-Indigenous settlement happened much later than in the lower 48 states. You had Russian fur traders initially, then whalers, fishermen.
And the U.S. acquired it from Russia, right?
Correct, through the Treaty of Cession, 1867. For a long time, recognition of Alaska Native land rights was pretty limited, mainly through the creation of some reserves and the eventual application of the Indian Reorganization Act to Alaska in 1936.
So, not the same treaty-making process as elsewhere in the U.S.
No, largely not. Then came Alaska's statehood in 1958. The Statehood Act allowed the new state government to select vast areas of federal land over 100 million acres. This put huge pressure on settling the question of Alaska Native Aboriginal title, as the state started selecting lands traditionally used and occupied by Native groups.
Because their rights were largely unrecognized legally.
Exactly. Without specific statutory recognition or treaties, their Aboriginal title claims were vulnerable. The Statehood Act did contain a disclaimer, saying the state wouldn't claim lands held by natives, but the scope of that was unclear. The discovery of oil at Prudhoe Bay in the late 60s added massive urgency.
Ah, oil. That changes things.
Always does. It led directly to the Alaska Native Claims Settlement Act, or ANCSA, in 1971. This is a completely different approach compared to treaties or reservations elsewhere.
How so? What did ANCSA do?
It was radical in some ways. ANCSA legally wiped out all Aboriginal title claims and Aboriginal hunting and fishing rights across the entire state.
Extinguish them completely.
Yes. In exchange, Alaska Natives received about $962.5 million and fee simple title to 44 million acres of land. But here's the key difference. The land and money didn't go to tribal governments.
Where did it go then?
It went to state-chartered for-profit corporations. ANCSA created 12 regional corporations based on geographic and cultural areas, plus a 13th for natives living outside Alaska, and over 200 village corporations.
Corporations, not tribes.
Correct. Alaska natives born before the deadline in December 1971 who had at least one-quarter native ancestry received shares in their respective regional and/or village corporations. The idea was to promote economic development and assimilation into the capitalist economy.
Wow. So governance and land ownership tied to corporate structures, what was the impact of that?
It's been hugely complex and debated ever since. On one hand, it gave native corporations significant economic power and involvement in resource development. Some have been very successful. On the other hand, it fundamentally altered traditional relationships to the land, bypassed tribal governments, and created tensions between corporate goals and cultural or subsistence needs.
I can imagine. Issues like non-natives working for the corporations or shareholders wanting dividends versus reinvestment in the community.
All of those things. Plus, the stock was initially restricted but later became sellable in some cases, raising fears about loss of native control. Governance in Native Alaska became this intricate web of tribal governments, which still exist and have relationships with the federal government, ANCSA corporations, nonprofits providing social services, and state and local governments. It's often fragmented, sometimes underfunded, and reliant on outside funding sources.
So ANCSA created economic opportunities, but also significant challenges for traditional governance and culture. What are the ongoing issues?
Key issues identified around the time of this source material included the need for clearer tribal rights regarding wildlife management, since hunting rights were extinguished, the right for Native communities to define their own political institutions beyond just the corporations, and developing governance structures that better address social and cultural needs alongside economic ones.
And how does ANCSA compare to settlements in Canada or Greenland?
That's a great point of comparison. The analysis suggests that because ANCSA was largely imposed by Congress rather than negotiated directly between equals, like some later Canadian agreements or Greenland's Home Rule, it resulted in less overall self-determination, particularly in the political and cultural spheres, compared to those models. The Canadian Comprehensive Claims and Greenland's Home Rule involved more direct negotiation and often resulted in stronger political institutions and rights recognition.
Very interesting. Okay, let's pivot to Greenland then. That's another unique situation, indigenous self-governance within a European kingdom.
Yes, Greenland, colonial, offers a powerful example of contemporary indigenous self-governance. The Inuit population there has achieved a significant degree of autonomy within the Kingdom of Denmark.
This started with home rule.
Right. Home rule was established in 1979, transferring power from Denmark to Greenlandic authorities in many areas. And that relationship has continued to evolve towards even greater self-government since then.
What does their government structure look like?
They have a popularly elected parliament, the Inatsisartut, formerly Landsting, and an executive government, the Naalakkersuisut, formerly Landstyre, led by a premier. Below that, the country is divided into municipalities, each with its own elected council, and even smaller settlements often have village councils. It's a multi-layered system of democratic governance.
And what about the economy? What drives it?
Historically and still significantly, it's fishing and hunting. But there have been periods of mining cryolite, zinc, lead, coal, and there's ongoing interest in potential offshore oil and gas reserves, which is obviously a major focus for the self-governing authorities in terms of potential revenue and environmental concerns.
How do they approach resource management and the environment? Is traditional knowledge valued?
Very much so. There's a strong emphasis in Greenlandic governance on recognizing traditional environmental knowledge and practices and integrating indigenous values into tackling modern environmental challenges, like climate change, which is having a huge impact in the Arctic.
And Greenland plays a role internationally too, doesn't it?
A very active one. Despite being part of Denmark, though handling most of its own affairs, Greenland participates directly in international forums relevant to the Arctic and indigenous peoples. The UN, the Inuit Circumpolar Council, ICC, the Arctic Council's Environmental Protection Strategy, AEPS, the International Whaling Commission, IWC, the North Atlantic Marine Mammal Commission, NAMMCO. They also have bilateral cooperation, for example, with Nunavut in Canada.
So they punch above their weight on the world stage.
You could say that. Greenlandic leaders were really instrumental in the rise of indigenous internationalism in the latter half of the 20th century, helping found organizations like the World Council of Indigenous Peoples and the ICC. They've been leaders. And importantly, the Danish government has generally been supportive of Greenland's path towards self-governance.
So Greenland stands out as a strong example of negotiated, evolving indigenous self-government with significant control over internal affairs and resources and an active international presence.
It's definitely a key model often looked at in these comparative studies.
Okay, let's stay in the Nordic region, but shift to Scandinavia. What's the situation for the Sami people?
The Sami are the indigenous people of northern Scandinavia and the Kola Peninsula in Russia. Their traditional territory, Sapmi, stretches across Norway, Sweden, Finland, and Russia. The situation regarding their rights and governance varies quite a bit between the Nordic countries.
How so? Let's take Norway first.
Norway has gone furthest in constitutional recognition. Their constitution was amended to state that the government must create conditions enabling the Sami people to preserve and develop their language, culture, and way of life. They established a Sami parliament, Sametinget, in 1989.
Does it have legislative power?
Primarily a consultative and advisory role to the Norwegian parliament and government, but it has significant influence, particularly on matters directly affecting Sami interests. There's also a Sami Act defining rights related to culture and, very importantly, reindeer herding. Land rights, however, remain a complex and somewhat unresolved issue, though there have been commissions and legal processes addressing it.
Okay, what about Sweden?
Sweden's constitution doesn't specifically mention the Sami people. A Sami Act in 1992 did lead to the establishment of a Sami parliament there, too, again, mainly with an advisory role. Land rights are arguably even more contentious in Sweden. Some historical rights were recognized, but then significantly curtailed by legislation in the early 20th century, and comprehensive solutions haven't really been achieved.
And Finland?
Finland also has constitutional recognition of the Sami as an indigenous people and guarantees their cultural autonomy within their homeland region. They have a Sami parliament as well, focused on cultural self-government. But, like in Norway and Sweden, land rights remain a major ongoing issue, with disputes over forestry, mining, and infrastructure development in traditional Sami areas.
So across Scandinavia, we see Sami parliaments with varying degrees of influence, mostly consultative, but persistent challenges around land rights. Is international law relevant here too?
Very much so. Article 27 of the ICCPR, the right to culture, has been particularly important for the Sami. The UN Human Rights Committee has interpreted Article 27 as protecting economic activities that are essential to the culture of a minority community, like reindeer herding for the Sami.
So threats to reindeer herding can be seen as threats to Sami culture under international law.
Exactly. This has given the Sami another avenue to raise concerns about development projects that impact grazing lands, for example. It highlights how intrinsically linked their traditional livelihoods, particularly reindeer herding, are to their cultural identity.
So while Greenland shows a high degree of achieved self-government, the Sami situation in Scandinavia illustrates a different dynamic: recognized indigenous status, dedicated parliamentary bodies, but ongoing struggles, especially over securing comprehensive land and resource rights within the existing nation-states.
That's a fair summary. Different histories, different political contexts leading to different outcomes, but the underlying themes of cultural survival, land rights, and political representation are common.
This comparative perspective is really highlighting the diversity of approaches and outcomes. Let's bring it back to Australia now and look specifically at the land rights legislation that exists alongside native title.
Right, because native title, recognized in Mabo, applies where it hasn't been extinguished. But Australia also has specific laws passed by parliaments granting land rights, often on former reserves or Crown land. The big one, the model in many ways, was the Commonwealth's Aboriginal Land Rights Northern Territory Act 1976, the ALRA.
That was based on the Woodward Royal Commission, wasn't it?
Yes, Justice Woodward's recommendations were key. He advocated for communal title, making the land inalienable, meaning it couldn't be sold, strong protection for sacred sites, and ensuring Aboriginal people benefited from mining on their land. These became core principles of the ALRA.
How does it work? Who holds the land?
The ALRA defines traditional Aboriginal owners based on spiritual affiliation and traditional entitlement. Land is granted to Aboriginal land trusts, which are corporate bodies that hold the title. But the real power lies with the regional land councils, like the Northern and Central Land Councils.
What do the land councils do?
They are representative bodies elected by Aboriginal people in their region. They have significant statutory functions. They ascertain the views of traditional owners, manage and protect Aboriginal land, negotiate land use agreements, including for mining, and they direct the land trusts. They're very powerful and important institutions.
And the Act allowed claims to unalienated Crown land.
Yes, based on proving traditional ownership. This led to large areas of the Northern Territory being returned to Aboriginal ownership under the Act. It also provided mechanisms for joint management of national parks on Aboriginal land, like Kakadu, though that's complex, and Nipmuc, Catherine Gorge.
What about mining under the ALRA? That's often controversial.
It is. Under the ALRA, mining generally requires the consent of both the relevant land council, acting on behalf of traditional owners, and the federal minister. However, there's a controversial provision allowing the Governor General to override the need for consent if the mining is deemed essential for the national interest. But even then, detailed consultation processes are mandated.
So, a strong framework, but with a national interest loophole. How does this compare to state-based land rights laws? Let's start with South Australia.
South Australia was actually quite early. The Pitjantjatjara Land Rights Acts 1981 and the Marlinga-Tjarutja Land Rights Act 1984 granted large areas of inalienable freehold title to corporate bodies representing the traditional owners, Anangu Pitjantjatjara, Yakunatjatjara, and Marlinga-Tjarutja. These bodies have strong responsibilities to protect the land and culture, and consent is generally required for development.
So, similar principles to the NT Act, inalienable title. Corporate bodies, consent rights. What about other states? Victoria.
Victoria had much more limited and specific land rights legislation at the time this research was compiled, like acts granting title to particular parcels of land, Northcote, Framlingham, Lake Conda. Not a comprehensive scheme like the NT or SA.
New South Wales.
NSW has the Aboriginal Land Rights Act 1983. It set up a unique three-tiered system of land councils: local Aboriginal land councils, LALCs, regional Aboriginal land councils, and a state Aboriginal land council, NSWALC.
How are they funded?
A key feature was funding through a percentage of state land tax revenue for a fixed period, 15 years initially, intended to build up a capital base for land purchases and investment. The LALCs can claim certain Crown lands, and the Act also has provisions for Aboriginal ownership and co-management of some national parks. It also includes significant accountability measures for the councils, strengthened after an ICAC inquiry.
So, a different model focused on acquiring land and managing assets. Queensland.
Queensland's history was different, dominated by the reserve system. Much reserve land was converted to what's called deed of grant in trust, due GIT tenure, with elected community councils acting as trustees. Then, in 1991, the Aboriginal Land Act and Torres Strait Islander Land Act were passed.
Were these similar to the NT or SAX?
Generally considered weaker, they allow for certain lands, like former reserves, duchy land, some other categories, to be transferred to Aboriginal or Islander communities as inalienable freehold title, again held by trustees. But the range of land claimable was more restricted, and the consent rights over things like mining were generally less robust than in the NT or SA.
And what about local governance in Queensland communities?
The Community Services Acts established Aboriginal and Torres Strait Islander councils with local government-type powers on the former reserves Dugiite lands. Proposed legislation for broader powers didn't pass initially, though later reforms focused more on financial management aspects.
Okay, briefly, Tasmania and Western Australia.
Tasmania had made very slow progress on land rights by the mid-90s, relying mainly on a land fund to purchase properties. Western Australia had the Aboriginal Affairs Planning Authority Act 1972, which allows an Aboriginal Lands Trust, ALT, an appointed body, to hold and manage former reserve lands.
Can mining happen on those WA lands?
Yes, mining can occur on lands vested in the ALT with the consent of the Minister for Mines, who only needs to consult the Minister for Aboriginal Affairs. Importantly, there was no requirement to consult the ALT itself or the Aboriginal communities living there. WA also had the Aboriginal Communities Act 1979, allowing councils of recognized communities to make bylaws, but this was seen as limited.
And across all these different schemes, how is Aboriginality determined for land rights purposes?
It varies slightly, but generally relies on demonstrating descent from the original inhabitants, self-identification, and crucially, recognition by the relevant Aboriginal community. This often involves detailed genealogical work, using historical records, archives, and community knowledge. Verifiable family trees and communal recognition are key.
Right, so Australia has this patchwork quilt of federal and state land rights laws running alongside native title with quite different levels of land return, ownership structures, and control over resources.
Exactly. A very fragmented picture, with the NT and SA legislation generally seen as providing the strongest rights and title security among the statutory schemes.
Now, you mentioned land trusts and land councils. These are corporate bodies. How important is incorporation for Indigenous groups generally in Australia?
It's become essential, really, to hold land, enter contracts, receive and manage public funds, employ staff. Indigenous groups generally need to be incorporated legal entities.
What laws do they use to incorporate?
They can use the standard federal corporations law, now the Corporations Act, or specific state territory laws for associations. But a really important one, especially historically and for native title bodies now, is the Federal Aboriginal Councils and Associations Act, 1976, the ACA Act.
What does the ACA Act do?
It provides a specific framework for incorporating Aboriginal councils, which have a geographical basis often linked to former reserves, and Aboriginal associations, formed by groups with common interests. It establishes a registrar to oversee these bodies.
Has it worked well?
It's had a mixed history. Initially, it had fairly basic accountability rules. Amendments in 1992 aimed to increase accountability, partly driven by funding bodies like Aotearoa, the Aboriginal and Torres Strait Islander Commission, which existed then. But these changes also made the Act less flexible, introducing complex model rules that didn't always suit the diverse needs of different groups.
And how does this connect to native title?
Crucially, the Native Title Act 1993 specifically adopted the ACA Act framework for the corporations that are set up to hold and manage native title once it's determined. These are called Prescribed Bodies Corporate, or PBCs.
So native title holding bodies have to incorporate, often under the ACA Act.
Yes, and the Native Title Act regulations impose specific requirements on their rules, particularly around consulting with and getting consent from the common law holders, the actual native title holders.
Is the ACA Act seen as the best fit now?
There's been ongoing debate. Some argue for a more flexible incorporation law tailored to Indigenous needs, perhaps separating the incorporation function from strict accountability rules, which could be managed through funding agreements and service contracts instead.
Accountability seems to be a recurring theme.
It is. Indigenous organizations often face multiple accountability pressures to their local members, sometimes a wider regional constituency, and definitely to the government agencies that fund them, like Aotearoa historically and various departments now. Sometimes the roles, like that of the registrar versus the funding body, became confused.
Were there examples of accountability issues leading to reform?
Yes. The inquiry by the Independent Commission Against Corruption, ICA, into some NSW Aboriginal land councils led to significant reforms there, focusing on governance, financial management, and the need for better training and capacity building for council members and staff.
What about finding governance structures that are more, well, culturally appropriate rather than just standard corporate or local government models?
That's a key challenge. The Gibb Review back in the 80s recommended options like loosely incorporated Aboriginal community societies with community-chosen representatives, trying to bridge the gap. Part 3 of the ACA Act was intended to allow for incorporation of traditional governing structures, but it was rarely used.
Is the standard Australian local government model a good fit for Indigenous self-government?
There's debate about that. Some researchers, like Will Sanders, argue that local government is typically based on residency in a defined area, whereas Indigenous identity and connection is often based on kinship, traditional association, and descent, which might not align neatly with municipal boundaries.
But some Indigenous councils have worked well.
Yes, absolutely. The Torres Strait Island Councils, for example, have long histories predating Queensland legislation and considerable community support. They function effectively as local governing bodies, so it's not a one-size-fits-all answer.
What about the overall approach to self-government, top-down versus bottom-up?
That's a critical distinction. Historically, government approaches were often top-down imposing structures. There's been a shift, certainly in rhetoric and increasingly in practice in places like Canada and the U.S., towards bottom-up approaches where communities design their own governance structures. Queensland had an intended program called the Alternative Governing Structures Program, AGSP, aimed at this, but it didn't really get off the ground effectively.
So a need for governments to actually recognize and empower existing or community-designed structures.
Yes, particularly mentioned in the source regarding Indigenous communities on the Cape York Peninsula, where there was a need for Queensland law to formally recognize their governance bodies. There were also concerns about state bureaucracies controlling resources and calls for more direct Commonwealth funding to regional Aboriginal bodies to bypass some of that state control.
Okay, let's quickly clarify the roles under the Native Title Act. We mentioned PBCs. What about Native Title Representative Bodies, NTRBs?
Right, they're distinct. NTRBs, now usually called Native Title Service Providers, are organizations funded by the government primarily to assist Native Title claimant groups. Their job includes researching and preparing claims, handling compensation applications representing claimants in negotiations in court, and certifying agreements like Indigenous Land Use Agreements, ILUAs. Their functions were actually expanded under the 1998 amendments to the Native Title Act.
So they're the support organizations for claimants.
Exactly. And then the Prescribed Body Corporate, or PBC, sometimes called a Registered Native Title Body Corporate, or NTBC, is the entity established after a native title determination is made. It's the corporation, usually set up under the ACA Act or increasingly the Maine Corporations Act, that legally holds or manages the determined native title rights and interests on behalf of the common law holders.
And the regulations specify how they must operate.
Yes, particularly around consultation with the native title holders, there have been challenges and ambiguities in interpreting these regulations, as seen in cases like Mulgal People v. Queensland. It's a complex area, ensuring these corporate bodies truly represent and are accountable to the traditional owners whose rights they manage.
Okay, that distinction is clear. Now, let's look at environmental and resource management more broadly for Indigenous Australians. How does international law connect here?
International environmental and human rights law increasingly recognizes the rights and roles of Indigenous peoples. Think of the Rio Declaration, Agenda 21 from the Earth Summit, ILO Convention 169 on Indigenous and Tribal Peoples, the Convention on Biological Diversity, the Ramsar Convention on Wetlands, the World Heritage Convention. They all contain principles or provisions relevant to Indigenous peoples' relationship with their environment and resources.
And did Indigenous organizations in Australia use these?
Yes. Aotearoa, for example, was a strong supporter of the UN Declaration on the Rights of Indigenous Peoples. However, invoking international human rights mechanisms sometimes created tension with federal and territory governments, particularly when used to challenge domestic policies like mandatory sentencing laws in the NT, native title amendments, or heritage protection issues.
Like the Jabiluka uranium mine controversy near Kakadu.
Exactly. Concerns were raised internationally about the mine's potential impact on the World Heritage values of Kakadu National Park, which is Aboriginal land under joint management. It highlighted the intersection of environmental protection, Indigenous rights, and international scrutiny.
What are some examples of Indigenous groups getting directly involved in environmental management on the ground in Australia?
There are many, and it's a growing area. The Koanyama Lands and Natural Resource Management Office in Queensland was highlighted as a respected body involved in managing the Mitchell River catchment on Cape York. It was seen as evolving towards self-governance based on community development, sustainability, native title, and local control.
And we mentioned the Aboriginal lands trusts in different states have varying powers.
Right. And the PBCs holding native title are becoming increasingly important legal entities for managing native title lands and waters, according to traditional laws and customs, often entering into agreements for conservation or development. Corporate structures are really central to Indigenous governance now.
Are there specific mechanisms promoting Indigenous involvement in conservation?
Yes, two key ones are Indigenous and Protected Areas, IPAs, and cooperative management of government-owned protected areas. IPAs are areas of Indigenous-owned land or sea country that owners voluntarily declare to be managed for conservation. The government provides support through funding programs.
Can you give examples?
The source mentions early IPA projects on the Enangu Pichanchajara Yankunajachara lands in SA by the Mangere Aboriginal Corporation and by the Paraku Indigenous Group. There are many more now, covering vast areas of Australia. Joint management of national parks, like Kakadu, Uluru-Kata-Chuta, Nipmuc, and many others, is the other major approach.
Now, a big topic that runs through all of this is the idea of regional agreements. How do they fit in?
Regional agreements are seen as potentially much more comprehensive than standard ILUAs under the Native Title Act. They're about direct negotiation between Indigenous peoples in a region and governments, federal, state, local, to settle a wide range of issues beyond just native title rights.
So broader than just land use.
Potentially, yes. Overseas models, particularly from Canada and Greenland, show how these agreements can address things like political recognition, self-government structures, service delivery, resource revenue sharing, economic development, cultural heritage protection, a whole package deal for a region.
What are the key elements in those Canadian agreements?
They typically include clear definition of land title, often including subsurface rights, sharing of resource revenues, guaranteed hunting and fishing rights, and defined roles for Indigenous bodies in land and resource management, ranging from advisory to actual decision-making power on co-management boards or environmental assessment panels.
Examples like the Inuvialuit or Nunavut agreements we discussed.
Exactly. And the Yukon Umbrella Final Agreement, which set a framework for negotiating individual agreements with each Yukon First Nation, including self-government arrangements. The British Columbia Treaty Commission, BCTC, was set up specifically to facilitate these complex treaty negotiations. The Nisga'a Final Agreement in BC is often cited as a key modern treaty with significant self-government components.
What makes these agreements successful?
Key factors seem to be unity among the Indigenous negotiators representing the region, a willingness from government to negotiate comprehensively, and a realistic approach to the political and economic context.
Are there similar aspirations in Australia?
Definitely. There have been calls for regional agreements in various parts of Australia. The source mentions perspectives from the Kimberley region in WA, criticizing existing government administration as paternalistic and inefficient, and outlining potential areas for Kimberley Agreement: cultural heritage, land use planning, economic development.
And the Torres Strait.
Yes, Torres Strait Islanders have long aspired to greater autonomy, potentially through a regional agreement covering governance and particularly their unique marine environment and resources.
What would be needed to support regional agreements in Australia?
Recommendations often include direct Commonwealth funding to Indigenous regional bodies to build capacity for negotiation, support for developing community and economic strategies, involvement of elected officials, and using ATSIC, or its successors, as an advisory channel.
How do ILUAs under the Native Title Act fit in? Can they be like mini regional agreements?
ILUAs are important tools for making agreements about native title rights and interests. There are different types: body corporate agreements made with PBCs, area agreements made where there's no PBC but with authorized representatives, and alternative procedure agreements for specific kinds of development. Once registered, they bind all native title holders in the area.
So they provide legal certainty.
Yes, that's a major benefit for all parties. Indigenous groups, governments, developers like mining companies, they can authorize future activities in exchange for benefits, but they're primarily focused on native title issues.
So the argument is that Australia needs a pathway for more comprehensive regional agreements that go beyond just native title, potentially building on ILUAs but addressing that wider suite of governance, social, and economic issues.
Exactly. Agreements that can address constitutional development for Indigenous groups within the region, define local government powers, settle native title comprehensively, and integrate service delivery and economic development. It requires state and local governments to be involved too, given Australia's federal system.
It sounds like a way to move beyond piecemeal solutions.
That's the idea. A coordinated, regionally driven strategy based on an Indigenous vision, rather than just reacting to development proposals or funding cycles.
But the Canadian experience shows it's not easy, right?
No, it's complex and challenging.
Right.
Financing the negotiation process, achieving consensus among diverse Indigenous groups within a region, making difficult compromises, implementing the agreements effectively, making bicultural institutions work. These are all significant hurdles seen in Canada.
So it requires real commitment and resources from all sides.
Absolutely. The argument presented is that just settling native title claims or making ad hoc agreements won't automatically lead to effective regional governance. You need a deliberate strategy driven by Indigenous peoples at the regional and local level, envisioning integrated rights and self-governance, along with mechanisms or triggers that bring governments and the private sector to the negotiating table.
Okay, we've covered a huge amount of ground, comparing Indigenous governance and resource management across several continents. Let's try to synthesize.
It's clear there's immense diversity, isn't it? Different historical trajectories, treaties or lack thereof, assimilation policies, land rights legislation, constitutional recognition, modern agreements, all leading to vastly different situations today.
Definitely. From the corporate model of ANCSA in Alaska to the comprehensive self-government of Greenland, the ongoing land rights struggles of the Sami, the complex interplay of native title and statutory land rights in Australia, the duty to consult in Canada, the inherent sovereignty concept in the U.S.
It really underscores that there's no single Indigenous experience and no one-size-fits-all solution. Context is everything: historical, cultural, political, legal.
Were there any particular aha moments or surprising facts for you in revisiting this material?
For me, I think the sheer extent of native title extinguishment legislated through things like ANCSA stands out. Also, the degree of political autonomy achieved in Greenland is quite remarkable. And perhaps the persistent legal and political challenges faced by the Sami, despite being in relatively progressive Nordic states.
Yeah, those are striking points. We hope this deep dive has given you, our listener, who wanted that quick but thorough understanding, some valuable insights into these complexities.
It's a field where the details matter, but hopefully the comparative lens helps clarify the bigger picture themes, the ongoing struggles for self-determination, for recognition of rights, for meaningful participation, and control over land and resources.
So, to leave you with a final thought, considering all these different models and the persistent challenges we've discussed, what fundamental shifts, maybe in legal thinking or political will, are most crucial for truly advancing Indigenous self-determination and genuine partnerships in land and resource management?
That's the big question, isn't it? Not just in Australia, but globally. What does genuine respect for Indigenous sovereignty, justice, and environmental stewardship actually require from non-Indigenous governments and societies? Something to keep reflecting on.
Indeed. Thanks for joining us on this deep dive.